Herrera versus Wyoming presents a very interesting treaty question that's alive today, and it shows the enduring effect of issues flowing from an 1868 treaty between an Indian tribe and the United States. It's a simple fact pattern. You have a group of hunters who are Crow tribal members from the Crow Reservation in Montana. They're elk hunting for their families, subsistence hunting. They go over a fence, they're in Wyoming, and they shoot an elk over there, and they get arrested by the state of Wyoming, and they're charged with illegal hunting under Wyoming state law. Herrera takes the position legally: I'm a Crow tribal member, I'm exercising my treaty rights, you have no jurisdiction over me, state of Wyoming official. I can go into the areas and they're not occupied. Here you're dealing with a treaty from 1868 between the United States government on the one hand and the Crow tribe of Indians on the other. The U.S. said, here is a reservation of federal land that will be yours forever, Crow tribe. And then the treaty also says that the traditional rights that Crow people had to hunt and fish and gather, their so-called subsistence rights, in their traditional homeland, which was bigger than the reservation, than the modern reservation, would continue so long as those lands were unoccupied. So that's the treaty language. So go from 1868, and then Wyoming in the late 1880s becomes a state. And then in 1897, the federal government reserves a portion of northern Wyoming as the Bighorn National Forest. Bear in mind that treaty rights are statutes, they're the law of the land, they're enacted when the U.S. government has entered into agreements with tribal nations. Tribal nations are recognized in the Constitution. They're one of the four sovereigns that are in Article 1 of the Constitution. You've got the state governments, you have foreign nations, or foreign states as they're called in the Constitution. You've got the federal power, or the federal government, and then you've got Indian tribes. So the issue becomes, when the U.S. enters into a relationship, the federal government that is, with a tribe, what is the state's role and how does the state affect that? Herrera's best argument is that for a very long time, with many treaties in many parts of the United States, there has been a recognition that these off-reservation rights continue to be respected, and that if something is done differently in this particular case, it will affect all those other treaty rights and many other cases that the U.S. Supreme Court has adjudicated. In Mille Lacs, the court faced the issue of, did Minnesota's entry into the Union eliminate the Chippewa tribe's fishing rights in this off-reservation area? And the Supreme Court held in that case, with that particular treaty, the tribe still retained its off-reservation subsistence rights. Congress is the one that you ultimately have to go to change something concerning relationship with the tribe. The state of Wyoming is claiming there was a preclusive effect. The issue had been faced before, and that the Crow tribe had essentially given up all of its rights to hunt and fish by operation of law when the National Forest was created, or alternatively when the state of Wyoming was created, those lands ceased to be unoccupied. The state of Wyoming is very careful to lay out in its briefs the idea that when a purpose for even federal public land like a national forest changes and there are restrictions imposed, there's a body of law that says it's now become occupied for purposes of that term. It's not about physical occupation by settlers. So they point out, for example, that in a U.S. national forest like Bighorn, you can't go and build a house in it that can't be subdivided or whatnot. I mean, that issue was resolved back in 1897 when the Congress created the National Forest System, and Congress would have to change that. But that at that time, by imposing those restrictions, the land was no longer unoccupied. There are conflicts between, on the one hand, federal treaties with tribes, and on the other hand, states trying to administer their own affairs and enforce their own laws. This is an area of constant friction, but it's growing. There's no question there's more and more litigation going on about this.